Good evening and welcome to Courts Today by Livelaw. This is your host Urvashi Chauhan bringing you the latest updates on the legal front. This is your go-to source for all things legal. Let us start. A new development came in today regarding the issuance of notices to two members of the NCLAT for contempt for rendering a judgment that violated a status quo order issued by the Supreme Court. In view of the development, the judicial member, Mr. Rakesh Kumar, has resigned. The matter relates to the occurrences on 13th October concerning the hearing of disputes with regard to annual general meeting of Finolex Cables, which is going on before the NCLAT. In the morning session of that day, the Supreme Court issued a status quo order. However, NCLAT proceeded to deliver the judgment despite being informed about the status quo order. Upon inquiry, the two judicial members said that they were not aware of the Supreme Court's order, but this version was disputed by the lawyers from both sides who said that the order was mentioned before the NCLAT bench before it proceeded to deliver the judgment. During the last hearing, the bench of CJI Chandrachud and Justices J.B. Pardiwala and Manoj Mishra had issued show cause notices to Mr. Rakesh Kumar, the judicial member, and Dr. Alok Srivastava, the technical member of NCLAT. Today, while the matter was being heard, senior advocate P.S. Patwalia, representing Mr. Rakesh Kumar, argued that the judgment was pronounced on 13th October and the order of the Supreme Court was neither officially communicated nor brought on record. But the bench, on examining the CCTV footage of the proceedings, noted that the lawyers had orally appraised the NCLAT members about the Supreme Court's order and were carrying the printouts of the order in their hands. However, Solicitor General Tushar Mehta, appearing for the technical member Mr. Alok Srivastava, offered unconditional apology and admitted that the pronouncement of the judgment should have been deferred. As the bench was about to dictate the order in the case after expressing severe disappointment, senior advocate P.S. Patwalia informed the court that Mr. Rakesh Kumar had tendered resignation in the wake of the Supreme Court issuing a contempt notice. The Apex Court noted that the mentioned bench of NCLAT had undoubtedly acted in willful defiance of its order. Further, the court held the scrutinizer liable for not declaring the results of the AGM and observed that Deepak Chhabaria, the former Finolex chairman, was the beneficiary of withholding of the results. Therefore, the court penalized him and the scrutinizer and asked them to pay Rs 1 crore and Rs 10 lakh respectively to the PM Relief Fund. The bench also transferred the case to the bench led by the NCLAT chairperson for fresh consideration. The next update is regarding the disqualification petitions over Shiv Sena rift. A bench led by CJI today heard the writ petitions filed by Sunil Prabhu, member of the Uddhav Thackeray faction of Shiv Sena, and Jayant Patil, member of the Sharad Pawar faction of NCP, seeking expeditious decision by the Speaker on the disqualification petitions filed respectively against the Eknath Shinde and the Ajit Pawar factions. The bench expressed displeasure at the stand of the Maharashtra Legislative Assembly Speaker that he required time till February 2024 to decide the disqualification petitions filed by Uddhav Thackeray. On earlier occasions, the Supreme Court has pulled up the Speaker for delaying the hearing in the matter. Today, the court has directed the Speaker to decide the disqualification petitions filed in relation to Shiv Sena rift by 31st December this year. As regards the NCP rift, the court has granted time till 31st January next year. The Supreme Court today delivered the much-anticipated judgment in the bail application filed by former Delhi Deputy Chief Minister Manish Sisodia in the Delhi excise policy scam case. The court has denied him the bail. As you know, the excise policy framed by the government of National Capital of Delhi to boost revenue and reform liquor trade in 2021 was later withdrawn after allegations of irregularities in implementation were made and the Lieutenant Governor Vinay Kumar Saxena ordered a probe by the CBI. This policy, which sought to completely privatize liquor trade in the national capital, was allegedly used to grant undue advantage to private entities at the cost of the public exchequer and smacked of corruption. The investigations are currently underway. Manish Sisodia has been in custody since February of this year and is being investigated by both the CBI and ED. Today, the verdict was delivered by a bench of Justices Sanjeev Khanna and S.V.N. Bhatti that heard Sisodia's plea against the Delhi High Court, denying him bail in both cases. The Apex Court issued notices in his petition in July and had reserved the judgment earlier this month. Senior advocate Abhishek Manu Singhvi had appeared for Sisodia. In a statement filed before the Supreme Court, the centre has submitted that the citizens do not have the right to information regarding the funding of a political party. This is regarding the electoral bonds case. As you know, earlier this month, the Supreme Court referred the petitions challenging the anonymous electoral bonds scheme to a constitution bench of 5 judges. According to the scheme, a donor can buy an electoral bond at specified banks and branches using electronic modes of payment. The bonds can be bought for any value in multiples of rupees 1,000, 10,000, 1 lakh, 10 lakh or 1 crore. Political parties are not required to disclose the source of these bonds to the Election Commission of India. The name of the donor will also not be there in the bond. The petitions challenge this scheme as an obscure funding system which is unchecked by any authority. In this statement, the Attorney General R. Venkataramani on behalf of Centre has refuted the argument of the petitioners that citizens have the right to know about source of funding of a political party. He says that the judgments upholding citizens' right to know of the criminal antecedents of candidates cannot be extrapolated to mean that they have the right to information regarding funding of parties. That the electoral bond scheme does not impine upon any existing right of any person and cannot be said to be repugnant to any right under the Constitution. He has also stated that the scheme promotes contribution of clean money and adherence to tax obligations. A constitution bench of the Supreme Court will start hearing the batch of petitions challenging this scheme from tomorrow. Stay tuned with us. While hearing the writ petition filed by Aam Aadmi Party leader Raghav Chadda challenging his suspension from the Rajya Sabha during the monsoon session, the Supreme Court today expressed grave concern over the infinite suspension of a member of parliament and its impact on the right of the people to be represented. Chadda was suspended over the allegation that he did not ascertain the willingness of certain members whose names were proposed by him as members of the Select Committee for the GNCTD Amendment Bill. The Rajya Sabha chairperson suspended him pending the inquiry by the Privileges Committee following a resolution passed by the House. During the hearing, the bench asked whether the action of Chadda would amount to a breach of parliamentary privilege. The CJI pointed out that a member who disrupts the House is only suspended for the remainder of the session. The only charge against Chadda is that he did not verify the willingness of members before proposing to include them in the Select Committee. Senior advocate Rakesh Dwivedi, appearing for Chadda, said that he has already apologized for the act and expressed readiness to give a written apology to the chairperson as well. The Attorney General told the court that the resolution was passed by the House and the chairperson was only acting on that. He also questioned the jurisdiction of the Supreme Court to interfere with the exercise of privileges by the House. The bench ultimately adjourned the hearing till this Friday and asked both sides to file a compilation of their submissions. In another update, the Supreme Court today adjourned the hearing of Tamil Nadu Minister and DMK leader Senthil Balaji's plea seeking bail on medical grounds until next week. As you know, Balaji was arrested by the Enforcement Directorate in June this year in connection with cash for job money laundering case. A bench of Justices Aniruddha Bose and Bila M. Trivedi was hearing a special leave petition against an order of the Madras High Court dated 19th October, which dismissed Balaji's application for bail on medical grounds. Today, after an adjournment request was made both on behalf of the Legislators' Council and the Solicitor General, the bench deferred the hearing till next week. And now an update on the controversy involving use of the acronym India by a newly formed alliance of 26 opposition political parties. A PIL challenging the use of the acronym has been filed by a businessman, Girish Bhardwaj. He is aggrieved by the non-observance and no action taken on the representation given by him to the Election Commission of India and against the political parties who framed the new alliance. The plea seeks a direction on the political parties to prohibit the use of acronym and also on the Election Commission of India and the Union government to take necessary action in the matter. In August this year, the Delhi High Court had issued notice in the PIL. Now, in the counter affidavit filed by the Election Commission, it has told the Delhi High Court that it cannot regulate political alliances under the Representation of People Act. ECI has referred to a decision of Kerala High Court wherein it was held that there is no statutory provision mandating the constitutional body to regulate the functioning of political alliances. The ECI has also clarified that its reply should not be construed as an expression on the legality of usage of the acronym. A PIL plea has been moved in the Allahabad High Court against the proposed plan of destruction and demolition of various temples and Kunj Galis for the construction of public toilets, gardens, fountains, etc. for the Vrindavan Banke Bihari Temple Corridor project. Submitting that the Kunj Galis are religious heritage and places of worship for crores of Hindus, the plea filed by Pankaj Saraswat contends that demolition of the Kunj Galis would be violative of Article 25 of the Constitution. The plea explains cultural and historical significance of the Kunj Galis and the associated sentiments of the Hindu community. It further alleges that the state government, without conducting any social impact assessment, without obtaining prior sanction from the Archaeological Survey of India, and without environment clearances, intends to demolish temples which have been in existence for hundreds of years and construct toilets and VIP waiting rooms, shoe-keeping rooms, etc. at their place. According to the plea, this is a violation of the Constitution and is barred by the Ancient Monuments and Archaeological Sites and Remains Act, which prohibits any construction activity within 100 meters of a protected monument. Recently, the airfares to and from Gulf countries have skyrocketed. As a result, people employed there from India are unable to visit their families. The Kerala High Court was today considering a plea moved by the Managing Director of Safari Group of Companies challenging the exorbitant airfares to Gulf countries. The court noted that people are unable to travel as the ticket prices have surged. It noted that people who are working in the Gulf countries support our economy, and because of the exorbitant ticket prices, they are unable to meet their families in Kerala. The court further noted that market dynamics alone should not be the determining factor for fixing the air prices, because then the prices can get exorbitantly high. The court has urged the state government to take up the issue with the central government to help the Keralites employed in the Gulf countries to meet their family members. The court stated that the state government can have some rules to help the people working there who want to travel at least once a year to meet their loved ones. The matter has been posted after 10 days for receiving instructions from the Kerala government. Stay tuned with us. I hope you found this video informative and enjoyable. If you did, please consider giving it a thumbs up and sharing it with your friends. Do not forget to subscribe and hit that notification bell so you won't miss any of our future content. You can also support us by donating through the thanks button at the bottom of our videos, or consider becoming a member at just 89 rupees per month. See you tomorrow.